don't know, unless somebody sat it out. It's possible that someone was not sitting at that point, but who was it? Well, it wasn't. Yeah, it's possible that somebody was ill and didn't participate, but there was no dissent in the case. Rehnquist commanded a unanimous court in the case. And it's a little weird. The holding of the court, I think, has to be characterized as saying that a public figure has to prove actual malice if you're complaining about something that was published about him. But Falwell, it was clear that Hustler knew what it was publishing was false, and that meets the actual malice standard. But the twist that Rehnquist put on it was that if the jury finds that there's no reasonable reader who would believe that this was a true statement, then the libel claim must fail. So that's where we are with that. The next Hustler case that I put in the reader is a really hard case, in my view, and in the view of most people. Hustler magazine versus Diane Hersig sued Hustler for wrongful death, for damages for wrongful death, for the loss of her son, Troy D., who got a hold of a copy of Hustler that had an article in it called Orgasm of Death that described the practice of autoerotic asphyxia. It came as news to me. I never heard the phrase before this decision. And apparently autoerotic asphyxia involves masturbating while you're hanging yourself. And as the blood is cut off to the brain and you reach orgasm, your orgasm is unbelievably intense. And the article in Hustler magazine, in its series, part of its series on sex play, describes the technique, such as it is, of autoerotic asphyxiation. Well, Troy D., who was a teenager, got a hold of the magazine with that issue and apparently tried it unsuccessfully, in that the next day his best friend came into his bedroom and found Troy D. hanging dead with a copy of Hustler magazine open to that article at his feet. And the friend and the mother sued Hustler magazine for damages for causing Troy D.'s death. The article had an editor's note at the top of it, emphasizing the often fatal dangers of the practice of autoerotic asphyxia, put in solid caps, "Do not attempt this method." It warned readers at least 10 different times that the practice is dangerous and self-destructive and deadly. But the 14-year-old tried it and died. The jury awarded the mother $69,000 a long time ago, not a huge amount of money even then, $69,000 in actual damages and $100,000 in punitive damages. And Hustler appealed. The appeal was decided by the Fifth Circuit Court of Appeals that governs the Deep South. The case was never decided by the Supreme Court. The Supreme Court denied certiorari, and the final decision in the case was by the Court of Appeals. And the decision was 2-1, with the opinion written by Judge Alvin Rubin, sitting in New Orleans. And he starts out saying that the constitutional protection for freedom of speech is not based on the naive belief that speech can do no harm, but rather on the confidence that the benefits that society reaps from the free flow of ideas outweigh the costs that society endures when it receives reprehensible or dangerous ideas. Under our Constitution, there is no such thing as a false idea. We rely on a kind of reverse Gresham's law, trusting to good ideas to drive out bad ideas in the free market of ideas. And Judge Rubin acknowledges that there are certain categories of speech that are not protected by the First Amendment at all, and we've encountered those before. He recites, for example, obscenity, child pornography, fighting words, incitement to imminent lawless activity, libel, fraud, and so on, but he concludes that the Hustler article doesn't fit any of these categories. Well, even some kind of speech that's generally protected may be subjected to restriction by the government if the state has a compelling interest, and the restriction is narrowly tailored to serve that interest, and that's something that it didn't really govern this case, because the way the case was tried in the trial court was on the theory of incitement, that the Hustler article, in fact, was in the unprotected category of incitement to imminent lawless action. And Judge Rubin says we're doubtful that a magazine article that's no more direct than this one can ever constitute an incitement. But then, of course, the court refers to the main Supreme Court precedent on incitement, which is Brandenburg. And the Brandenburg test is that to be restricted as incitement, the speech has to be likely to cause imminent lawless action, imminent violence, and so on. And this doesn't fit the Hustler magazine context at all. As Judge Rubin points out, the boy mom would have to prove that autoerotic asphyxiation is a lawless act, that Hustler advocated the act rather than cautioning don't try it, that the publication went beyond mere advocacy and amounted to incitement, and that the incitement was directed to imminent action. And no fair reading of this article, hedged as it was with disclaimers and warnings, don't do this, could be considered incitement. Whether written material might ever be found to create culpable incitement is a question that the court doesn't reach. Well, Hersig's mom, Troy's mom, argued that this speech is not political. It doesn't have all of the protections afforded to core political speech, that this is sort of low-value speech, not worthy of complete First Amendment protection. Judge Rubin dismisses that notion, that saying that the Supreme Court generally has not attempted to differentiate between different categories of protected speech, didn't want the worthiness of speech to be judged by majoritarian notions of political and social propriety and morality, and therefore reversed the judgment upholding Hustler's right to publish an article that we have to assume, that caused death, that caused the death of the boy, provoking a passionate dissent by Judge Edith Jones on the Fifth Circuit. She's a very conservative judge, politically conservative judge on the Fifth Circuit. She was almost appointed to the Supreme Court by the first President Bush. She was sort of the runner-up for the position. And I think she may still be serving in court. She was a bankruptcy lawyer before she was appointed to the Fifth Circuit. But she was highly upset by the court's ruling in the Hustler case, saying that it foreclosed the possibility that any state might choose to temper the excesses of the pornography business by imposing civil liability for harms that it directly causes. She says this is suicidal pornography, and to deny responsibility for causing the death in this case is to degrade the market of ideas to a level with the black market for heroin. No federal court, she says, has held that death is a legitimate price to pay for freedom of speech. Certainly, no federal court has ever said that, but the effect of the decision is that free speech trumps the right of somebody to recover for death caused by a particular kind of speech. Then her reasoning, her legal reasoning for her dissent, comes down to her point that Hustler is not a legitimate competitor, but not a bona fide competitor in the marketplace of ideas. It is largely pornographic. That is, its main function is sexual arousal. Its principal function is to create sexual arousal. Pornography's appeal is therefore non-cognitive, unrelated to, and in fact exactly the opposite of the transmission of ideas. This is not ideas. This is selling sexual stuff. And as for Hustler's responsibility, a significant portion of its readers are adolescents. Hustler knows this. Clearly they do. I mean, they can put a plain brown wrapper on the magazine and put it in a section of the newsstand where minors are not supposed to buy it, but somehow or other, lots of teenagers get access to this magazine. Hustler knows that. And they have to know that couching an article about how to do something sexual with warnings is going to be lost on those teenagers. That saying, don't do it, it's dangerous, is as likely to be considered an invitation to teenagers as it is to scare them away from doing it. They are particularly, according to Judge Jones, vulnerable to thrill-seeking, recklessness, and mimicry. Warnings no or caution may be treated as invitations rather than taboos. She ends her dissent with a point that is a little off, and I just want to call your attention to it. She says the foregoing analysis differentiates this case from Brandenburg versus Ohio, which addressed prior restraints on advocacy of controversial political ideas. Is that right? Did Brandenburg involve a prior restraint? No, not at all. She's wrong on that. Brandenburg was a criminal case involving after-the-fact subsequent punishment, not an attempt by government to prevent publication in the first place. So where do you guys come out on this Hustler case, the Hersig case? Was the decision the right one? Ruby.
I actually think the decision was the right one. I guess I feel like in my generation, listening to her dissent, I really think she sounds like a prude.
Sounds like a prude?
Yeah, like, oh, this does not count as free market of ideas. I guess she's more of a social liberal, and that's why I think what she says has no value on that point. And also her, I think I actually have a question on the trial court decision. They said that it was in second of lawless action.
Yeah.
How is Haynes lawless action?
I don't know. I suppose, encouraging suicide may be a crime in Texas. The case was tried in Houston, Texas. I'm not sure about that. I mean, the theory was really far-fetched to call it incitement. There have been subsequent cases involving death where the theory was negligence, and those courts have split. One was a book called Hitman, which was basically a manual for how to carry out a contract murder. And book publisher put out the book called Hitman, and sure enough, somebody who bought the book arranged for a contract murder of his business partner, and the survivors of the murder sued the book publisher for damages for having wrongfully caused the death by negligence, on the ground that the publisher should have known that somebody out there would pick up on the tips in the Hitman manual and carry out a murder. And the Court of Appeals, Federal Court of Appeals, upheld the liability in that case. There was another case very similar that went the other way. The Supreme Court has not addressed that issue. And there's a whole bunch of cases involving liability for the publication of false information that causes injury. Just by way of example, let me mention one that did not involve litigation at all, but you all know Dr. Ruth Westheimer, the little Jewish lady who was the expert on sex, and written a number of books on sex, sexual advice books. And she wrote one on sexual advice for teenagers, in which she had a chapter, was talking about contraception, and she had a chapter on the rhythm method of contraception. And she said in this book that the safe times to have sex, the safe times are the week before and the week of ovulation. And the book went out saying that. It was distributed around the nation, and she had read the galleys before the book was finally printed and hadn't caught the typo, meant to say the unsafe times. And there was no litigation about it. But what if some girl, following Dr. Ruth Westheimer's advice to the letter, following it to the letter, got pregnant? Should she be able to sue the publisher of the book for damages for causing her pregnancy by giving her bad advice, wrong advice? How do you react to that, Nicole? Was an innocent mistake. Yeah, but shouldn't the publisher take some responsibility for fact-checking and verifying the accuracy of what they put out? Yeah, Dasha?
Say someone's reputation was ruined by somebody publishing committed suicide, could the family then sue and maybe their chances of winning it?
Yeah, well, I'm not sure where we go with that. The thing with the Dr. Ruth with the bad medical advice is, if the girl, my hypothetical teenager, who wants advice about the rhythm method, had gone to Dr. Ruth as a doctor, and Dr. Ruth gave her that advice, clearly the doctor would be liable, right, for malpractice, for delivering to a patient incorrect medical advice, causing damages. Well, why is that different from, I mean, here's Dr. Ruth telling millions of girls that same advice. Why should she be off the hook in that instance, where she's liable if she does it one-on-one? Yeah, that's an interesting point, because I think the oath, do no harm and so on, relates to a situation where there's a duty owed by the doctor to the patient to exercise the proper care in delivering medical care or advice. In order for there to be liability for negligence, which is what the claim against Dr. Ruth would be, the malpractice would be negligence. She hadn't acted as a reasonable doctor would in the circumstances. In order for there to be liability for negligence, there has to be a duty of due care owed by the person who caused the injury to the person who's injured. That means that in the Dr. Ruth situation, you would have to say that there's a duty owed by publisher or author to the world at large, whoever might pick up this book and read it and get the wrong information. And the courts are generally not willing to say, because of the tug and pull of the First Amendment, that a publisher owes a duty to the entire world to get it absolutely right. Dasha? Yeah, I mean, if a lawyer gives a client bad advice, that's malpractice. It's negligence, and yeah, lawyers get sued for it. Doctors get sued for it all the time. Kat?
Well, I think that's because like factual that like that's when you would get pregnant is why. Like it's not subjective advice. And also I was wondering it's because she couldn't be sued because she didn't knowingly publish this false information. Like she thought she had said unsafe. You know, sometimes when you proofread, it's like you put the unnecessary label. Obviously, you would not want to have sex that. You know, like, so is that sort of protection? Because I'm sure she would testify like.
Well, we don't know because there was never a case brought that would decide that issue. On Thursday, we're going to consider two really great First Amendment decisions. Lots of issues. Inherently interesting, the American Booksellers case on treating pornography as sex discrimination, and the violent video games case. So do your homework. We'll talk on Thursday.